Hey there, good day to everybody. How are you? This is Spencer Sen, your estate planning coach. Certainly, one of the things that I really provide to as many people in a day as I can is clarity. Clarity about estate planning. Anything that I've ever done in my life, that's been a major theme, is helping people reduce it and simply get clarity. And I wanted to talk through, like, just every day I run across this, and it's so hard to see because this is so simple, yet the majority of people don't have the right information. And that's why I do what I do, why I created my Facebook group, why I created the company and estate planning coaching that I have, is really just to help people learn and understand and get clarity how we can protect our families, our assets, the things that we build and do in our lives that we work so hard on. And I'm very candid in this. I don't want people to take this as I'm talking bad about attorneys or the system or anything, but I share the candid truth with people. And also, I'm not an attorney, okay? But you don't have to be an attorney to teach and help people get clarity and understanding about estate planning, their options, what they qualify for, what they don't qualify for. My purpose is to arm everyone or as many people as I can in a day with the information they need to have clarity to make an educated decision about what's best for them. Okay, so let's cover that real quick, very simply. All right, so if you don't have any assets, and let me clarify that. Sorry, I got something in my eye here. For example, each state has its own threshold or dollar amount that really determines whether you have assets or not. Okay? So, most people have heard of probate, but they don't really understand it. But probate is a law in every single state. Every single state says if you own X, which is called the threshold, anything more than that, your estate can end up in probate. Now, there are variables to that, okay, which makes it a little bit more complicated, but not hard to understand. So, in Wisconsin, in a couple of other states, a number of other states, if you own $50,000 or more in probatable assets, okay, really where you really, in order to qualify that, they really want you to go through probate, and I'll explain that. If you own a home or more, okay, if you own property or more, okay, more investment accounts, other type of things, and you'll run into financial advisors that say all you need is a beneficiary. Totally untrue. Any asset can end up probatable depending on, there's different things in life that can happen, unplanned, unexpected, that can create that asset to have to go through probate. Okay, so if you own more than $50,000, each state has its own threshold, but Wisconsin and a number of other ones, if you own 50,000 or more, but you really want to start if you own property or not, okay, and or more, okay, meaning larger amounts of money, 70,000 and other type of investments or anything that can end up in probate. All right, so if you don't have that, okay, if you don't have assets that go over $50,000, what do you need in place? Okay, all you need is a will. I shouldn't say all you need. That's not reducing it down to a will. Most people think a will is all they need and it protects them from everything, which is completely false. A probate law is designed to prove a will. So what does that mean? If you only have a will and you have assets, that will is going to force you into the system. You're going to go through probate. Your surviving family is going to go through probate because you'll be gone. Okay? They're going to have a lengthy process. It's a hassle. It gets costly. Family discord happens. There's all kinds of variables, risks, and issues, and the judge decides everything. The system decides everything. Okay? And the will is not even a valid will until the end of that process, which the average is 15 months, where all assets are frozen until that proceedings are done. Okay, everything becomes public, Everybody is notified. Anyone can contest it. Okay, let's keep this very simple. So if you have over $50,000 in a property or more, and you only have a will, you're going to go through probate. Your surviving family will go through probate, okay, to help transfer the titles and the assets over to where you want. All of that can be prevented. But let's focus on, if you don't have assets, what you need then is a will plus power of attorney finance. There's 3 different types. The only one that goes beyond incapacity and follows you everywhere throughout life is a durable power of attorney finance. Okay, not a general or a limited. Those are specific to if you're getting a procedure. Those are general and limited. We'll talk about the healthcare one in a second. The second one is a healthcare power of attorney. Again, durable. You don't want a general, you don't want a limited, okay? Well, oftentimes when you go into a hospital or a doctor's office, they say, can you please fill out this? It's a power of attorney. That's for compliance, for HIPAA compliance. That does not follow you. That's a general or a limited. It's the hospital or the doctor's office responsibility to provide that to you, and that also protects their butt. Okay? That does not follow you outside of that procedure. Okay? You need a durable healthcare power of attorney. Most people, I come across it, 9 out of 10 people say, I've got a power of attorney, and I ask how they got it, and they say they had a procedure. Okay? That is not a durable one. That is not what you want. So, you need a will, power of attorney finance durable, power of attorney healthcare durable, and then you need an advance directive, also called a living will, which is a deeper dive on how you want to be taken care of or not in certain situations, giving your power of attorney the answers so they don't have to be influenced by others or be stressed out and anxious about coming up with the answer of what they think you would want and how you would want to be cared for. So if you don't have assets, you just need the will, power of attorney, healthcare, power of attorney, finance, and an advance directive. If you have assets, a property and or more, okay, then you're going to want to have, if you want to avoid probate, there's one tool that will allow you to cover all your bases and eliminate all of the variables and risks. There's a number of different options to do this, but we call them Band-Aids. A transfer on death document, adding your kids to your deeds. There's all kinds of other issues that can happen with that. A trust is the only legal way to eliminate and privatize and avoid probate and make sure that you control any variables that can happen, that it cannot end up in probate. Okay? So a trust covers everything. Then you need a power of attorney, healthcare, finance, advance directive, a pour-over will, transfer on death documents, pay on death documents, bill of sale stuff. Okay, that now is more of a complete and comprehensive estate plan. But to help people on a daily basis understand this is what I do, because 9 out of 10 people do not understand it. Why? Because the system in place doesn't teach us. Attorneys are not going to teach you everything. They make money to help us solve problems, and when there are holes and gaps as life unfolds, they get called in again to help us solve those problems or our surviving family. All of that can be prevented. That's what I try to help with, to arm each and every one of you with the correct information, the complete information, and simple clarity so you can make an educated decision based on what's best for you. So if you have questions, reach out to me. Through this video, in the comments section. If you can like it, that would be fantastic. It just attracts more people to be able to learn and get the clarity that they need. I help people throughout the country, and I have a estate settlement planning. It's called Estate Settlement Planning on Facebook, a private group. Request to come on into it and get your answers to your questions and get more clarity. God bless and good luck to everybody.